Halay, sorry, Halayahay? Okay. From the Department of Economic Planning and Development, we have Attorney Diane Faye Losa, Ms. Savina Jean Lavarias. From the Department of Foreign Affairs, we have Deputy Assistant Secretary Annalyn Ratonel. From the Department of Public Works and Highways, Attorney Mary Aiza Manalastas. From the Governance Commission for GOCCs, we have Attorney Domingo A. Reyes IV and Attorney Ira Critia Manaligod. From the National Privacy Commission, we have Attorney Lee Ann Santos Javier. From the National Security Council, we have Attorney Camille Angelica Gonzalez. From the Civil Service Commission, we have Ms. Noreen Butz Gozon Garagasin. From the Office of the Court Administrator of the Supreme Court, we have Deputy Court Administrator Leo Madrazo. From the Presidential Communications Office, Attorney Maria Danica Orculio, Ms. Grija Casey Avejar, Ms. Jaya Illustrissimo. From the Philippine Drug Enforcement Agency, Attorney Joseph Frederick Kalulut and Attorney Michael Manjares. From the Union of Local Authorities of the Philippines, we have Mr. Edmond Quaresma. From the Right to Know Right Now Coalition, we have Attorney Nepomuceno Malaluan, Ms. Malu Mangahas, Attorney Irene Joan Aguila, and Ms. Jillian Roque. From the Anti-Money Laundering Council, we have Mr. Anthony Lawrence Morales. From the Institute of Government and Law Reform of UP College of Law, we have Attorney Celeste Simbrano Malyari and Attorney Marilyn Quizon Mercado. From the Department of Information Communications Technology, we have Engineer Michael Stephen Gorospe. Mr. Chair.
Thank you everyone for joining us today. My dear colleagues, distinguished guests, and stakeholders, our Secretariat, good afternoon to all of you. We convened this meeting to hammer out the provisions in the ever-so-elusive Freedom of Information Bill. I recognize that it has been more than 3 decades since the first ever version of this bill. But now, the passage of this measure, aptly called "The Right to Information," is within our reach. After all, it is the right of every Filipino to have a transparent and accountable government. Ladies and gentlemen, we are not doing this simply because Congress is reacting to the current political climate. Rather, we want our people to have access to information that will allow them to participate meaningfully in government. At present, we have political and private sector momentum to pass this measure. This is a golden opportunity. Pagtulungan po natin buuin ito, a bill that strikes a balance between public accountability and the right to privacy of every Filipino. Maraming salamat po. Before we proceed, I would like to manifest that our reference bill is House Bill number 6206. It is our working draft, primarily because most of its provisions were already discussed and approved by the TWG in the 18th Congress. And I believe some of you or your organizations were part of that TWG. I was also informed that aside from consultative meetings with the committee, our resource agencies and stakeholders also conducted alignment meetings to refine this same version. We sincerely appreciate your meticulous review of this bill. I believe among yourselves, you have reached consensus on several provisions already. So should there be provisions that require discussion or further amendment, di na ganon karami. So allow me also to manifest the inclusion of 4 other bills covering the same subject matter which were referred after our initial meeting on December 10. House Bills number 6786, 6970, 7210, and 7306, and will be likewise considered in this TWG deliberation. As you know, this is a LEDAC priority. So we want to make sure that we recommend it to the mother committee using the best version possible and approve it in time for our target in June. For our reference, the Secretariat emailed the reference bill, House Bill 6206, and the matrix, which includes Senate Bill 1432, filed under the Committee Report Number 5, and our House Working Draft. We will flash on screen the proposed provisions as of February 20, taking into account the submitted position papers and discussions during pre-TWG meetings. We would also like to acknowledge Representative Chel Jokno of Akbayan Party List and Vice Chairperson Brian Poe and Mr. Patrick Akupan of FOI Youth Initiative. With the assistance of the Secretariat, I will guide the discussion provision by provision to ensure that all proposed amendments are clearly stated, properly recorded, and thoroughly deliberated upon, and that areas of agreement and disagreement are duly noted for incorporation into the next version of the draft substitute bill. As customarily done, we will leave the title, short title, and definitions for last. We can proceed to Section 2, Declaration of Policy. So, any comment? Section 2, Declaration of Policy. Saan yung akin ito? Basahin natin? Mahaba na. Itong amendment. Consistent. Ha? So I think you all have the matrix. On the left, we have the reference bill and the proposed amendments on the right. I will give you time to read. So there's a proposed amendment. The second paragraph, consistent with Article 19 of the International Covenant on Civil, etc., etc. Do you have any comments on this particular amendment? No comment? Ito. Ni Brian? Sila lang? Sila lang yung nakalang meeting by themselves? Okay. We move to the third paragraph. So we added further, pursuant to Article 3, Section 7 and Article 2, Section 28 of the Constitution. Are you okay with this? No comment. We move on to the next paragraph. Or, kung wala silang comment, tapusin na natin.
Pwede kong basahin. Kasi hindi nila makita.
Can all of you read the clearly? Basahin ko na lang just to make sure for those who cannot see it properly. So let's start with the third paragraph. Further, pursuant to Article 3, Section 7 and Article 2, Section 28 of the Constitution, the state recognizes and affirms the right of the people to information on matters of public concern and adopts a policy of full public disclosure of all transactions involving public interest, subject to the procedures and limitations provided by this Act. As a democratic country, it shall be the declared policy of the state to promote transparency, increased meaningful participation of the people in government decision-making, and public accountability. It also recognizes the vital role of communication and the free flow of information in nation building. Further, the state acknowledges the growing role of emerging technologies, including artificial intelligence, in information access, processing, and dissemination. In harnessing these tools, the state shall ensure their ethical, transparent, and accountable use to prevent misuse, safeguard the integrity of public information, and uphold the rights and welfare of the people. In pursuit of these objectives, the state likewise upholds and protects the fundamental human right to privacy, recognizing it as a necessary safeguard against unwarranted disclosure of personal and sensitive personal information. The state shall endeavor to strike a fair and lawful balance between the free flow of information and the right to privacy in order to foster innovation, growth, and the public good. Okay, so any comments on Section 2, Declaration of Policy? Wala. So moving on to the next section. Okay, so let's formalize this. Do we all agree on Section 2, Declaration of Policy? Okay, so this Section 2 is approved. We move on to Section 3, coverage. I would like to get a sense of the body regarding Section 3, coverage. I think we should just take time to read it again right now for a few seconds, and then we decide if we take this as is.
Chair, clarificatory question.
Yes, Representative Tinio.
For Section 3 coverage. So this, of course, kasama dito lahat ng mga branches of government, etc. So wala tayong problema dyan. This is more of a clarificatory question. Okay. So it applies to any natural or juridical person, including but not limited to any public service contractor, concessionaire, grantee, supplier, entity, etc. That is the second to the last paragraph. So, iklaro lang. So, yung mga covered po rito, para malinaw lang, no? Yung mga franchise holders, so private entities that hold government franchises. For example, yung sa MRT or say for example mga radio or TV broadcasting companies and so on. Lahat ng merong concession or kontrata sa gobyerno, kahit private corporation. For example, PPP, under a PPP arrangement. So covered po rito. Ngayon, my concern is often batay sa karanasan natin, in some cases, meron mga sinasite na non-disclosure agreements. No? So, paano ba yon, Mr. Chair? If it's like a private corporation that has a concession or contract with government, tapos some terms, are not easily accessible, especially to members of the public, because, may mga ganung sinasite. So, ibig pong sabihin nito, wala na yun.
May we have the opinion of Right to Know right now? I think you guys were the ones who introduced this amendment.
Mr. Chair, I think just by way of background of this provision, yung mga nauna pong historical versions of the bill limits the coverage of this law and the right to information to government entities. And even jurisprudence so far has not yet clarified whether this right extends to private entities. In reality, Your Honor, the bill of pushed by the Right to Know Right Now coalition did not include such expansion. It was in the current chair's bill that expansion was included. What the R2KRN did was to further clarify on the scope kung kailan siya mag-a-apply, and that's why these are the letters A, B, C. So it is an expansion of or further clarification of when or the conditions under which this bill will apply. That's the first comment, Mr. Chair. The second comment which we mentioned to the PCO when it did the alignment meetings was the observation that because historically this bill only covered public entities, the rest of the bill, if you will look at it, are all geared towards the administrative details of how it applies to public entities. And so the only comment we made was that perhaps there will need to be a mention of that the IRR should also provide for how it applies to private entities. So just to clarify, Your Honor, that the expansion of the coverage to private entities did not originally come from the Right to Know Right Now coalition. What came from us is that given the direction of including it is to provide this letters A, B, C, D to circumscribe what or when it will then apply. I don't know if I was able to clearly state the position of R2KRN, Mr. Chair.
I think that's a good enumeration, considering that we are including any natural or juridical person doing business with the government. Is that?
Yes, Chair. Actually, I agree and support the inclusion of this in the coverage. Dapat lang naman lahat ng mga private corporations, entities na nakikipag-deal sa gobyerno, merong kontrata sa gobyerno, merong prangkisa, etc. Dapat covered sila nito.
Alam natin.
Para
Yung
malinaw
transaction.
yung terms, di ba? So I just wanted to...
Your question is on the NDA.
Yeah, minsan sa karanasan may mga ganon, no, na biglang sasabihin ng ahensya, may NDA kami, kaya hindi namin ma-share. Parang may ganon na akong na-encounter, no? So, well, with the passage of this law, I don't know if how siguro that could be covered by exceptions. The exceptions.
Siguro the general rule is that
to disclose. Tapos
the NDA will not be acknowledged unless it is one of the exceptions.
Siguro, parang ganon. Or the inclusion of NDA will have to be in accordance with the provisions of this act. So, merong mga bagay na pwedeng makover ng NDA, pero yung iba relating generally to public interest, hindi pwedeng makover ng NDA. Baka ganon. Hindi ko alam. Baka may input dito yung mga executive agencies, no?
Yes.
Mr. Chair, just to complete also our statement. We support the expansion of the coverage, and in fact, we have a pending case before the Supreme Court precisely for that purpose, Mr. Chair. Just to clarify also my earlier comments. Thank you.
Just to, konkretong example lang, Mr. Chair. During the budget deliberations, nag-question tayo sa NIA, National Irrigation Authority, or si Department of Agriculture. NIA yata to. Because lumabas na meron silang something like, was it 600 million peso contract with Microsoft? No, with, not Microsoft, with a company associated with Microsoft for weather forecasting software. No, so naintriga tayo bakit napakalaking halaga, no, para dito sa software services na ito. So dinala tayo ni administrator sa kanyang opisina, dinemonstrate yung software, pero hindi naman tayo binigyan ng kopya ng actual contract between NIA and that software company. We didn't really press for it, pero yun yung concern natin. Baka mamaya mag-invoke sila ng mga NDA dito. No? So, yung ganong scenario ang hopefully ma-address, no, ng inclusion, hopefully this will be addressed with the expansion of coverage of the Freedom of Information Act. Yun lang, Mr. Chair.
Maybe this expansion of the coverage already addresses that. Diba? Parang
Mas maganda nga, Chair.
it doesn't need to be said. Kasi it's very clear na it shall further apply to any natural or juridical person as long as they're doing business with the government.
Thank you, Chair.
Any
Mr. Chair?
comments? Yes.
Yes, just another question in relation to coverage. Would, for example, the Independent Commission on Infrastructure be covered as by the provisions as written? Kasi parang baka po hindi.
You mean the proceedings under the ICI?
Yes.
Or any other commission?
Yeah, other commissions created by, let's say, the chief executive.
Maybe it's already included in the independent and oversight bodies created by the Constitution or by law.
Ang problema lang po kasi if they really try to be technical about it, say we cannot provide you with that information, especially when I am referring particularly to the ICI because I understand that before they went public with the live streaming, it was very difficult actually to find out what was happening and what documents, etc., have been submitted. Kaya ko po tinatanong, Mr. Chair. Perhaps if I may suggest that we just add the phrase or executive order. So by law or para lang clear na wala silang leeway na magsabi na hindi sila covered.
That is a good suggestion, Representative Jokno.
Thank you, Mr. Chair.
So let's just add it to one of the proposed amendments. May I also ask who introduced the amendment in the first paragraph of Section 3, the head of state and members of the cabinet? The head of state and members of the cabinet, constitutional offices, independent and oversight bodies created by the Constitution or by law. Head of state. Do we also include the head of state or the vice president?
By head of state, president po yun.
Yes.
President.
So,
Ba't din lang president? Bakit head of state ang ginagamit? The president and the members of the cabinet. The president, vice president, and members of the cabinet.
yes, we can, I think we could also change it to president, vice president, and members of the cabinet.
Mr. Chair, good
Yes.
good
Yes,
afternoon.
ma'am.
Yeah, I'm from the Right to Know Right Now Coalition and a journalist by training. I would just like to clarify that there is really no additional context for the provision on coverage of private entities doing business with government. I think all our friends in government here know that there is transparency or public disclosure of contracts per se. And data could be available from across a number of government agencies, Securities and Exchange Commission, the implementing or contracting agency. But I think what is the beauty of this draft bill is that it sets clarity, it defines clarity and standards for disclosure when somehow private parties also should feel equally responsive and responsible to such requests. The problem is when only government agencies are held to account, when in fact, well, the success or the lack of success of certain projects rests on the two parties, the government and the private sector. But it is not an additional, I would think, it's not an additional coverage aspect. It is really clarifying exactly what should be a shared responsibility of government agencies and private sector to respond to requests for information. Just a clarification.
So, any other comments on Section 3 coverage? Are we all in agreement with the provisions of Section 3? Yes, sir.
Just a comment on the, and probably a recommendation. Because here, unlike all the rest of the enumeration, it is the office, the government office that is covered and is obligated to provide the information. And it is in this phrase, president, vice president, and members of the cabinet, it now becomes the person himself or herself. And then it becomes in effect, an obligation of the person rather than the office itself to provide the information. So just for consideration, perhaps the offices and so on based on the enumeration, but then it already speaks of the executive. So just for consideration of the chair. Thank you.
Yes, I think you're right. is already included in the executive. So pwede na natin tanggalin yan. No?
Mr. Chair, we concur po with the comments of our colleagues from Right to Know Right Now Coalition. Initially, the head of state, members of the cabinet, was introduced by our partner in the international experts in the right to access to information. So some of the countries, they state their coverage with the persons, specific persons, like the head of state, president, vice president, members of the cabinet. But in this case, in the Philippine context, since we are again we are mandating the government offices instead, so we concur to remove the head of state, president, vice president, and members of the cabinet instead. They are inclusive or all-encompassing in the executive, legislative, and judicial. Thank you.
That's true. Any other ideas? Para bilisan natin to. Medyo busy tayong lahat eh. So, alam mo, parang we have to work fast. Okay. That was a very good observation, Attorney Danica. Thank you. So we will strike it out. Anything else? Anything else that you've noticed regarding this? And so we move on to section 4. Well, since the definitions are going to be bloody, let's move it to the last part na lang. Let's go to section 5. Does everyone have their own copy of the matrix? Okay, let's take a few moments to read. Okay, section 5, Right to Information Commission. Any comments? No comments? So, I think the significance of the second paragraph is that it will only be attached to the Office of the President for policy and program coordination purposes. Although I'm not very well versed as to what policy and program coordination purposes means as differentiated from actual supervisory or control, supervisory control over the commission. But if there is no objection, if there is no comment against this, we can include this in the amended version.
Mr. Chair.
Yes, ma'am.
Good afternoon, everyone. The Commission on Human Rights would like to manifest its recommendation that the Commission should be independent, regardless of its purpose to being attached at the office or on the office of the President. Kasi it would feel like it defeats the purpose of being independent, and it would also...
You mean to say that totally independent
Yes, totally
and not
independent.
attached to the office of the President?
Yes, to ensure as well the impartial discharge of its functions and powers outlined in the proposed bill, regardless of its specification. Thank you.
What do we get by having it attached to the office of the President? Does anyone know? From the executive?
Mr. Chair.
Yes.
Yeah, good afternoon from the Civil Service Commission.
Yes, ma'am.
I'd like to suggest, and I think I agree with our, I think from COA? CHR. All right, so it would seem that when we describe RTI as an independent and quasi-judicial and still attached to the office of the President, that formulation might create some structural ambiguity. So while attachment in the administrative law, and I think that's what's being asked here, refers to administrative supervision. So our suggestion is to amend and to read that it is attached to the office of the President for administrative supervision only. So
What do you mean by administrative supervision?
Yeah, so that will clarify that the attachment is administrative in nature. So
What does it mean to be administratively under the supervision of the office of the President?
So in terms of budget purposes, among other things, the Office of the President will have, they will have to connect during budget deliberation. And, well, that's I think the major part of, and also some of the rules pertaining to some administrative functions, especially those that are within the ambit of the civil service, or under the rules in the Civil Service Commission.
So we will change this to the commission shall be attached to the office of the President solely for administrative purposes. And we will remove policy and program coordination.
Yes, and if I may suggest also, Mr.
Yes,
Chair.
I think it's also clearer if we just put it as administration purposes.
Yeah, administrative supervision only.
And what was that, ma'am?
So, for clarity, we may add, for your consideration, such attachment shall not impair the independence of the Commission in the exercise of its quasi-judicial regulatory and policy-making functions.
So we can change the second, you're saying that we should change the second sentence. Because the second sentence says, such attachment constitutes a lateral relationship for purposes of coordination and reporting and shall not include supervision or control. I think we should remove that and replace that with your clearer suggestion instead.
All right, thank you.
How about the others? Do you agree? Yes, ma'am.
Mr. Chair, thank you so much for the inputs po, ma'am. We would like to assert that it is stipulated on the first paragraph of the Section 5, the word independent, and it somehow contradicts with the word independent of being administrative.
Administratively under the supervision of the office of the
Yes.
President. You have a point. How about the others? I think the independence will still be achieved even if it is under the administrative supervision of the Office of the President, as long as its main functions are not influenced. Akin lang yun.
Mr. Chair.
Sorry.
Mr. Chair, if I may be recognized.
Yes.
Pag nawala po sa, if it's not no longer attached to the Office of the President, baka mawala po yung appeal process. So, saan po sila mag-a-appeal if there's, in case something, they wanted to have clarification with the information.
Diba may appeal process din ata siya eh. May, yeah. Oh.
Sige.
Ms. Danica, kaya ba na totally independent yung commission on its own without any attachment to the Office of the President, do you think?
Well, in the international jurisdiction, Mr. Chair, usually it's an independent. So it's not attached with the executive, judicial, or legislative. But in this case, in the Philippine context, we followed the structure of the National Privacy Commission. So under the National Privacy Commission, there are also an independent body, but attached under the DICT. So for I think for policy, I think for policy coordination purposes as well. So that's what we want to replicate.
But we're not
here.
doing any policy coordination with the Office of the President. It's only for administration
Yes.
this time. So it might not be necessary anymore?
Yes. We concur with the comments of the CSC. So we may instead use the word solely for administrative purposes only for the budget. Yes.
For budget purposes?
Yes.
Ms. Patricia, can we allow it that it will be, attached to the Office of the President? Is it really a big deal na totally independent, walang administrative attachment, whatever?
On behalf of Commission on Human Rights, we will be asserting that it shouldn't be attached to any government agencies for the sole purpose or for any purposes that you would like to mention, because it is stipulated clearly in the first paragraph that it should be independent and among other things, and that unless we would otherwise remove the independent word because it defeats the purpose of being independent and being operational on its own.
Are there any other independent commissions which have attachments to other agencies?
NCIP,
NPC?
example.
The Philippine Competition Commission is also under the administrative supervision of the Office of the President. And is it an independent commission? So baka pwede lang. Kasi may ibang agencies na rin eh. I guess if it doesn't really get into the heart of its independence, then it's not a problem. Yung sa inyo lang, it goes against the first paragraph which has the word independent, right?
And if I may speak in Tagalog, para
po.
mas tagos sa puso natin. Maybe because ang pinanghuhugutan natin dito ay as much as we wanted na maging independent siya or for the sole purpose of administrative supervision, magpo-pose pa rin iyon ng challenges on its implementations and operations kasi as an institution, and ayaw nating malagay sa ganong sitwasyon yung komisyon kung sa maiipit siya sa kanyang mga duties and functions.
Dahil may connection talaga sa Office of the President. Parang you're saying that it has to be totally independent.
Yes, if the body will allow.
Yes, ma'am.
I appreciate yung context ng Commission on Human Rights. I'm a journalist. Ang tingin ko, in theory and in practice, those are two things. So when you say independent, Congress is supposed to be independent. The judiciary is supposed to be independent of the executive. But I think the spirit of the text here is that by function and by powers and mandate, it should be independent. But I have a problem in mind. How do you make it, how do you create it in the first place? How do you give birth to it? If it's totally independent, it cannot be that, it suddenly is there. But I'm saying only that the dependence is not really in terms of just consulting with the president all its actions and decisions. We could have, in theory, and it's a firm theory here, it should be independent. If we move the story forward, in practice, it could be absolutely independent because its powers are clearly defined here. That's the same for the constitutional commissions, meaning not attached, but also somehow engaged with the executive and Congress and the judiciary. I don't think would cut the umbilical cord entirely. How do we give birth to a very good institution like this if it cannot have any advocates or associates in government? That's my concern.
Anyway, we can note your, but of course, we have to finalize this so we can move forward. So I would tend to agree that it is not that hindi siya ganun ka deal breaker kung i-attach natin sa Office of the President. Parang it will not undermine the independence of the Commission. As long as the powers are fully defined and there's a clear delineation between the Office of the President and the Commission itself. So we will stick with having it attached to the Office of the President solely for administrative purposes, for administration purposes. Any other comments? Yes, ma'am.
Good afternoon. Sir, perhaps to be able to capture the points raised, maybe we can have an express exclusion as well. So aside from mention that, sir, perhaps we can include a sentence that says, in the exercise of its adjudicatory, enforcement, monitoring, and rulemaking functions under this Act, it shall be free from any supervision, direction, control, or interference from any department, agency, instrumentality of the office of government, including any of its officials or employees. So it's, aside from stating the express independence, we also state the express exclusions from interference of anyone else, just to preserve all the other functions or powers that cannot be captured, or it cannot be, at least by any stretch of the imagination, will not be construed as falling under administrative. I think maybe that's just to preserve the true independence portion. So the first part will be the express statement of its being independent and attached laterally or administratively for purposes of budget, but a second sentence that says that in no way is it going to fall under any, will there be any interference for these particular functions, just so that it's categorically stated.
Yes, I like it. Any comments? How about Ms. Patricia from the CHR? Are you amenable to that, since we are already putting an express provision of the exclusions of interference on the part of the President, or on the part of the Office of the President?
Mr. Chair, perhaps we can just submit a formal position paper once this meeting is done.
Okay, but can we include the suggestion. Sige po, thank you. That was a very nice inclusion. So let's move on to section 6. Yes, sir. May microphone po tayo.
Mr. Chair, for this section on the right to information commission, so we would like to clarify whether the additional policy, there will be an additional policy function that will be assigned to the RTI, given that the commission is actually assigned only as a regulator, not a policy making body.
Ano po yun? Sorry.
We would like to check if we will add additional function which covers policy making. Kasi ang ang function lang ng commissions is covered lang niya is regulation, adjudicatory, and enforcement function. So if we remove kasi yung policy and program coordination, sino na magke-create ng policy
Tama.
later on?
So ilagay natin yung policy and program coordination na tinanggal natin kanina.
Or perhaps kung if the body would be amenable, we can add additional policy function on the RTI if it does that actually operational.
Yes. Yes,
Sir,
ma'am.
in response to that, may I invite the attention of the body to section 13, paragraph C, the functions, under functions and duties of the commission. I believe this is included in the draft po, pending before the committee. It actually states explicitly that the commission has the power or the function, duty, to issue policies, orders, and guidelines in implementation of the act. It's po in the original draft pending po.
It's already in section 13.
Okay. To that effect, we would like to propose a language on the right to information commission. So,
Yes.
So under okay, wait, see the original section 5. There is hereby created an independent and quasi. Okay, wait lang for a while. The commission shall also serve as a policy primary policy making body for this for the implementation of this act.
So your suggestion is to enumerate in section 5? Ano yung final version ng section 5? Yes.
For in the portion of in the exercise of its policy making or policy making functions, adjudicatory and enforcement.
In the exercise of its policy making.
To make it explicit.
Okay naman. Okay na yan, engineer?
Yes, sir. Yes, Mr. Chair.
Okay. So, anything else? Wala na? Let's move on to section 6. Any comments?
Mr. Chairman. Mr. Chairman, may we know who would be appointing the members of the selection committee, considering that under Section 6, it is explicitly provided that the President shall appoint the chairperson and commissioners of the RTIA. But in this section, the appointing authority for the selection committee is not indicated.
That's true. So should we include a sentence which says that the President shall appoint? That is a very good observation. Thank you. Maybe we can put it after the second paragraph. Submitted by an independent selection committee. The selection committee shall be appointed by the President.
So the chair would like to recognize the Honorable Congressman Remulla. Thank you for joining us. Could we request for the positions on Section 6, discussing the composition of the commission? Would anyone like to be recognized? No objections, no concerns regarding this section? Yes, from CHR.
Clarificatory question lang po. Yung mga ma-appoint po na chairperson and commissioners, is this permanent in nature po ba? Thank you.
I believe there's tenure. There's a specific time. Hold on. A 7-year term, I believe, is the proposal. Yes.
Would like to manifest po that we have received a different version. Could we please send the latest version po? If anyone from the Secretariat.
Which version do you have? Do you know which author? Or is it the consolidated? Because the consolidated should have the term of office in it. Wala pa.
Wala po yung mga edits na may blue or highlighted. Not this one po. Yes po, actually.
Ma'am, can we clarify? Is your concern regarding the selection committee? The term of office for the selection committee? For the commissioners and the chairperson. Then Section 7 should have that.
Okay. Yung na-receive po namin na version is wala po yung selection committee and other edits.
Okay. Sige, we'll get you the latest version of the bill. Pasensya na. Okay, any other concerns regarding the composition of the commission? So seeing as there's no concern, I think we're okay with this. Section 6, could we move on to Section 7, please?
Mr. Chairman.
Yes, you're recognized.
Yes, with regard to Section 7, could we also include the tenure of the members of the selection committee, since it is only limited to the term of office for the chairperson and commissioners of the RTI? That's all, Mr. Chairman.
Sige, we will direct the committee to do so. Maybe, do you have specific wording that you would like to see in this section?
We do not have any specific wording, but maybe the members of the technical working group could provide a tenure for the members of the selection committee.
May I ask what the recommendation would be, whether we should have shorter terms or longer terms for the selection committee? Would anyone like to manifest a position on this? 3 years, 5 years, 7 years, 6 years? Just for the sake of having it in the provision already, para we can move on to the next section. We'll come back na lang if anyone has any strong feelings. But would you like to suggest maybe we could do 7 years? Or too long? For the selection committee.
Mr. Chairman?
Yes.
I think 7 years is too long. How about let us adopt the term of office of the members of the Judicial and Bar Council, like 4 years?
Okay. Tentatively, we'll adopt that version. So 4 years, similar to the Judiciary Bar Council, or the JBC. I believe the Right to Know Right Now Coalition has a proposed amendment for this. May we hear your proposal?
Sir, this is for the selection committee. Well, we're just suggesting this is a possible structure as well. So this selection committee shall be constituted and convened within 15 working days from notice of an impending or actual vacancy in the commission. And then the term of the members of the selection committee, perhaps it can be that the selection committee shall serve only for the duration of the selection cycle for which they are constituted, beginning from the date of the constitution until the submission of the shortlist, because there's actually no need for the selection committee once the shortlist has been submitted. To maintain the selection committee might be a waste of government resources, and to give it a false mandate it does not have. So maybe it basically is constituted and then dissolves after the names are submitted. That's a permutation that we can explore. There. So.
Does anyone have any strong feelings against that? It's a pretty good suggestion to save on government resources. Sir, is it okay with you?
We're amenable to that,
all
Mr.
right.
Chairman.
So we'll adopt that amendment instead of the 4 years recommendation earlier. With no other concerns, maybe we can move on to the next section already. Yes. You're recognized.
Good afternoon. I'm Attorney Eve Car Cruz Ferrer from the Local Water Utilities Administration. I'd like to also manifest or include that we consider who will comprise the selection committee. From which agencies or institutions will the members of the selection committee come from? That's another thing. Or maybe another permutation to the suggestion earlier proffered is that if we have this selection committee, should there be a vacancy for whatever reason, the same, the original selection committee may be called upon in order to deal with that vacancy instead of having to come up with new members every time.
Could we request for your position in writing, para we can study it and see where it fits best, if ever?
Actually, Mr. Chair, it's more of for the consideration of the committee. Since we've included a selection committee, but we've not identified who shall comprise this selection committee. It's something the committee should consider.
Yes. Representative Tino, you're recognized.
Chair, baka walang kopya ang ating resource person. Meron po sa provision na enumeration ng mga pwedeng ma-compose sa selection committee.
We have not been provided as well of that particular copy. The matrix was not provided.
Okay. I think we'll be providing you with a copy so that you can take a look at the wording. But there are some provisions regarding that. Kaya I was asking for your position in writing na lang. So with that concern set aside, any other concerns regarding the selection committee? If none, let's move on to Section 8 already on vacancies.
Mr. Chair. I'm from PCO, sir. Sir, in front.
Oh, in front. I'm so sorry. Yes, okay. Yes, attorney, you're recognized.
Mr. Chair, for the Section 8 vacancies, we would like to manifest the executive director who will perform the function of a commissioner, since technically, there's no next in rank if there's a vacant position. So it will be a concurrent capacity, in his concurrent capacity. Yes, Mr. Chair.
Does anyone else have an opinion regarding who the next in line would be, aside from executive director, if you have any suggestions? If we could take a look at section 11. Is this the person that you were referring to? Who would be next? So yung executive director. Okay. Is everyone amenable to that? Or does anyone have any strong feelings or objections regarding this? No, I guess we're okay. Any other concerns regarding Section 8, vacancies? Kindly take some time to look at the proposed amendment. Okay. Seeing as how there's no other concern regarding Section 8, maybe we can move on to Section 9 already for qualifications. Would anyone like to raise any suggestions regarding Section 9? Before anything else, I'd like to recognize the presence of Representative Cutie Delmar. Thank you for joining us. So currently we're discussing the qualifications for the chairperson. If anyone has any suggestions or concerns, the only concern that we have here regarding the Section 9 is that the in terms of style, the sentence is way too long. If it's okay with everyone, we're just going to make a minor adjustment, and so right before the first comma after probity and before and, we'll just turn that into a completely different sentence already. So it will read, the chairperson and the commissioners shall be Filipino citizen and at least 35 years of age and of good moral character, unquestionable integrity, and known probity. And then period. Then next sentence would start with have distinguished themselves, etc. That's okay with everyone, I'm sure. No? All right. Thank you. Can we move on to Section 10? I feel like that's a bit more controversial than Section 9. All right, let's move to Section 10 on prohibitions and disqualifications. Does anyone have any concerns regarding the amendments that have been suggested here?
Mr. Chair, if I may be heard. Yusik Abot from ARTA.
Yes.
Regarding the second paragraph of Section 10,
Okay.
since we have actually haven't or have not agreed upon the independence of the commission, it says here the complaint shall be filed before the office of the president, and it seems this would be inconsistent with our objective to make it independent.
Okay. So in lieu of that, what would you suggest? Where should they file their complaint?
Mr. Chair, it would be under the purview of the Office of the Ombudsman.
Well, I don't know about you, but I trust the ombudsman. So, so we'll make that distinction. So, Office of the Ombudsman.
Thank you, Mr. Chair.
Any other concerns or suggestions? Right. So if there are no other concerns regarding Section 10, just want to give you another chance to look at it again, because this also includes the grounds for removal in case you have any missing concerns. But I think this covers everything already. Let's move already to Section 11 regarding the Executive Director, which is also important considering this person would be next in line in potentially OIC. Any strong feelings regarding the qualifications for Executive Director?
Mr. Chairman?
Yes.
Do we have a minimum age for the Executive Director?
That's fair. I'd assume that it should be 35, but we should put it in writing, no? Do we have a representative from the Civil Service Commission? Yes, ma'am, would you like to comment?
I'm not sure if putting a 35 here, because it would seem that you're requiring a 10-year experience, and that would make 25 plus. Mr. Chair, for gender-sensitive language, you might want to consider chairman as chairperson.
We'll make that change. Thank you for bringing that up. We'll change that to chairperson instead of chairman. And then regarding the 35-year, but the requirement for the commissioner is 35 years. So if the executive director is going to succeed the commissioner, should that not also be 35 years? I mean, yes, technically that means since they graduated, they should have been working in ICT. But if they're a commissioner, if they're an executive director of the commission at 35 years old, they must have had quite some experience now. Continue. Would you like to?
Okay. Well, let's just revisit the requirement, the age requirement for commissioners. But ba merong 35? What's the rationale for that?
So, pwede sila mag-senator after. No, just kidding.
Kaya nga, so why? Is there a hard age requirement? Meron bang...
Kasi po may 10-year experience na hinihingi.
Okay,
The end
well,
of the
so
first-
let's just put 10 years experience, pero
They graduated ng
hindi naman
20 or
necessarily 35 yon, di ba?
I'm in favor of that. If we can remove the age limit and just keep the work experience. Sa tingin ko, mas mahalaga naman yung work experience versus the age. Not for any specific reason, but yes, I feel like work experience is more important than the age. So, if we could go back to section 9 real quick. So under section 9, we have our qualifications for the chairperson. If the body is amenable to it, we will remove the minimum age requirement and emphasize the work experience requirement of a minimum of 10 years.
Mr. Chair, if
Yes.
I may recognize. For the reference of the 35 years of age, it was patterned from the qualification of the National Privacy Commission commissioners, so under the Data Privacy Act. But it will be the wisdom of the committee if we want to remove the qualification for the age requirement.
Parang may pagka-arbitrary yung 35 eh. Why 35? I mean, ano bang mangyayari pag 35 ka na?
For me, if we're talking about the right to know or the right to information, and we want to attract the more idealistic government leaders, they're most likely going to be younger naman talaga. So I would suggest that we do without the 35-year restriction and encourage younger people to serve in government. We can set the tone with this new commission.
Chair, ikaw, ilang taon ka na ba?
Not that I'm positioning for it, 33. So I wouldn't have qualified. But I have 10 years government experience, so, diba? Read it out. Could we have someone read out the new version of Section 9 considering the removal of the age restriction?
Both for the commissioners and the executive director, ang requirement 10 years.
Yes, po.
Experience in the field. Parang ganon.
Yes, it would be a minimum requirement of 10
Sige,
years for both. So at the very least, more or less, they'll most likely be 30 years old. Yeah, fresh grad, and then, I believe there are certain work experiences that qualify as relevant work experience. Okay, great. I'll read the new version of Section 9. So Section 9 now reads, the chairperson and commissioners shall be a Filipino citizen and of good moral character, of unquestionable integrity and known probity. They shall have at least 10 years of relevant experience with proven knowledge, experience, and eminence in the fields of law, governance, public administration, human rights, social development, journalism, information and communications technology, ICT, data science, statistics, management, or media and communication. The appointees may come from the following sectors: government, business, academe, labor, rural or urban poor, or members of concerned civil society organizations, non-government organizations, or people's organizations. I feel that that's relevant and wide enough a breadth to be inclusive in its selection.
Mr. Chair, from the National Security Council.
Yes.
Yeah, I would just like to ask for clarification if the chairman and the commissioners should have experience in all of these fields, in law, governance, public, or in any of the fields.
No, I believe there's or. Yes, it says or, right before media and communications.
Thank you, Mr. Chair.
Thank you. Would you like us to put national security background? All right, so let's go back to Section 11 on the Executive Director. So in Section 11 for the Executive Director, we agreed that we're not going to put an age and we're going to keep the 10-year work experience in any of the following fields listed, which is similar also to the head of the commission. So no objections, no other concerns. We'll move to the next. On Section 13 on functions and duties of the commission, the commission shall have all the powers and direct or incidental as necessary to undertake its functions under this act, including but not limited to the following. We have a few changes in blue. Subsection B, subsection D, and then some subsections D, E, and F were removed. Subsection K was also removed, and subsection N. Do we have any strong objections to this or concerns? I'll give you a minute to read through it. So just for the knowledge of the technical working group, we will proceed until Section 15 to make time also for session. But so if we can move quickly, Section 13, do we have any other concerns? Or are we okay with the provisions that have been amended and removed?
Mr. Chairman.
Yes.
We provided functions and duties of the Commission under Section 13. And Section 14 provides for the powers of the Commission. However, the law is silent on the functions and duties of the executive director. Are we not supposed to also include that in our draft?
Maybe we can request for it so that we can work on it until the next technical working group, because that, I believe, will be a new either section or subsection. If we could request for a position paper on what those duties may be, although they will probably be quite similar to the commissioner himself. But ComSec, please take note. So we'll move from section 13 to section 14, seeing as how there's no more recommendations. Under section 14, we're now discussing the powers of the commission. There are only a few minor amendments in blue. Subsection B, which I believe is more of style, and then subsection I. This one you may want to look into a bit more because it considers the limitations. And then a new section at the bottom. May I ask for the wisdom of the technical working group, what are your thoughts on subpoena power? So I know we're gonna get asked this later on.
Mr. Chair, if I may,
Yes.
I think that should be included in the powers and functions of the Commission. As you all know, our own agency has limited powers. We do not have that subpoena powers, and we're having problems in the implementation of our enforcement mandate. So I'm just suggesting that we include that in this law.
With due respect also to our judicial bodies and to the DOJ, etc., maybe could we get us? Is anyone here from the DOJ? No. Maybe. ComSec, maybe in the next technical working group we can invite a representative. We have. All right. Attorney, would you like to give the DOJ's position on subpoena powers? We're currently on section 14 on powers of the commission. The wisdom behind it is we also don't want it to be a lame duck commission. Like we know the blockages that they will encounter if they do not have subpoena power, but we also want to give due respect to the current, judicial bodies that have authority on this matter. But I don't want to force a statement now. If you want, maybe you could submit a position paper from the DOJ before the next technical working group so that we can have clarity on this.
Yes, Mr. Chair. Actually, I was just about to mention that considering that we were also just provided a copy of this updated matrix, the department would formalize our position thereon at a later time. Thank you.
Okay, thank you. ComSec, maybe we can give them a copy of this version. All right, so aside from subpoena powers, are there any other powers of the Commission that we may want to consider that hasn't been listed here, that we also haven't discussed over the past 20 years? Anything that may be an overreach of power of the Commission while we want to add power to the commission, we also want to make sure that we're not reaching into someone else's jurisdiction. Okay. Well, seeing as how there's no other comments regarding Section 14, again, just following up with the DOJ, we will be expecting that position paper. And so now we move on to Section 15, immunity from suit. Would anyone want to raise a concern regarding this? Maybe any suggestions?
Mr. Chair, if I may.
Yes.
For consistency, it appears here that the authority of the President to remove the commissioner is still in place, considering that we want it to be an independent commission.
Right.
So maybe we can revise it.
Okay. We'll instruct the ComSec to make the necessary revision.
Mr. Chair.
But this is an appointment of the President, so he should technically have the power to. Because this isn't necessarily a matter of more of just the removal. Do you have suggestion on the wording?
Sorry. No, Mr. Chair. It pertains to the previous section, the Section 14, on the subpoena powers.
Okay,
so
going back to Section 14.
It was not expressly or explicitly mentioned, the subpoena, but it is part of the subsection A and subsection B power of the Commission to require relevant public officials or individuals in possession of pertinent information to appear before it to provide testimony or produce documents. So
yes,
yeah.
I mean that's why I asked about it, because it's here in spirit, but not in writing. It needs to be explicit, because this is going to be a loophole that will be exploited in the future. So I just want to make sure that either A, we're going with a harder stance in which we really want them to have subpoena power, or B, we want it to be lighter, in which they can reach in, but they can't necessarily force the submission of certain documents. Thank you. So going back to Section 15, aside from the revision regarding the authority of the President to remove, which we've discussed, is there any other concern here?
Mr. Chairman.
Yes. Yes, you're recognized, Attorney.
Under Section 15, the general rule is the chairperson and commissioners are immune from suit. The exception is if those actions or omissions are done in evident bad faith or gross negligence. However, the determination of bad faith or gross negligence lies with the judiciary when a case is already filed. So I think we need to reconcile this provision, Mr. Chairman.
Anyone else want to chime in, make a point regarding this? So your suggestion would be that we do it the same as the other. We give the authority to the Office of the Ombudsman.
Yes, Mr. Chairman. Let the wheels of justice just roll and let them face the suit if ever there's any omission or bad faith on their part.
I think the spirit as to why the authority is given to the President is so that the President can quickly change, if necessary, the head, regardless of whether or not there's a pending case. If I'm not mistaken, is that not the...
Chair, I think yung nire-raise ni Attorney
Kalulut from PIDEA, Mr.
From PIDEA,
Yes, sir.
Attorney Kalulut. Basically, pinatatanggal niyo yung immunity from suit.
Yes, sir. Because,
yeah.
It's contradictory since generally they're immune from suit, but the determination of bad faith or gross negligence lies with the judiciary. So kailangan mag-file muna ng kaso para malaman kung merong bad faith.
But okay, so
parang ang intindi ko, Mr. Chair, the way this is written, sabi may immunity, but there's the but there's an exception except for those actions and omissions done in evident bad faith or gross negligence, which basically cancels out the immunity. But there can only be an investigation if there's a complaint filed, diba? Siyempre, any complaint will claim that there's gross negligence, etc. Diba? So parang practically wala na rin tong immunity na to, unless unqualified immunity from suit period.
Well, I want to ask the wisdom of the technical working group here, because there are two thoughts at play here. One is we make it immune so that they can really do their investigations without the fear of being bogged down in cases. No, because most likely if they're doing investigations for the right of information, there will be pushback. Someone will try to file cases and bog down the commissioner. On the flip side, if we don't allow the ability to file cases against the commissioner, then we also, does that not defeat the purpose or spirit of right to information? Should we not have the right to complain, no, about the commissioner if we feel that there's an abuse of power? Because there's a possibility to do that as well. Imagine, lalo na if nagkaroon ng subpoena power and they can get whatever documents on whoever and target certain government officials. So, does anyone have any civil society? Do you have any thoughts on the matter?
Yes, good afternoon. So I believe the reason why it's here is to be able to ensure that quasi-judicial bodies need some ample decisional independence. There should be some sort of protection against harassment suits, but not a license for immunity. That's precisely why I think it's couched in, the complainant needs to allege evident bad faith or gross negligence in the performance of quasi-judicial functions. It's just to cancel out harassment suits, because you do need to give some ample leeway for that kind of an independence in the exercise of their quasi-judicial function, to be able not to, bog them down with harassment suits. But in the same vein, we don't want to give them a license to perform things that are evidently in bad faith or grossly negligent in the performance of such quasi-judicial functions. So the burden initially will rest on the complainant to make allegations of fact that point to evident bad faith and gross negligence. Absent that, the complaint cannot proceed. I think that's the spirit of it, so that you weed out harassment suits from the get-go and allow the commissioners to be responsible and accountable for acts that do have badges of bad faith and gross negligence.
Is there a way to, sorry, I'm consulting my colleagues here also. Is there a way for us to give oversight to, for example, the committee? So, for example, they're immune from suit, but they still report to the committee. Kasi, like, for example, a legislative franchise, diba? You have to go back to Congress to renew your franchise. Obviously, if we keep this immunity to suit, it's going to be difficult to file cases against the commissioner. But if the commissioner has to report regularly to Congress, that might be a way for us to balance out potential harassment lalo na if we give subpoena power.
And Mr. Chairman?
Yes.
This is also to harmonize the earlier amendment made wherein the members of the commission can only be removed through the cases filed with the ombudsman. So if they can be removed by a case to be filed by the ombudsman, then this provision should also be deleted, since this provides for the immunity of suit of members of the commission.
Yes?
Yes, Mr. Chair. In consonance with this particular provision, there is no provision for administrative liability. So this pertains only to civil and criminal actions. So a complainant can file an administrative action with the Office of the Ombudsman if there is a gross negligence or there is evident bad faith in the official function of said commissioners. So I think they can still be removed from office and action can be still filed.
Comsec, can we write to that language so that at least it's in black and white that